And it looks like a few people are still calling in, so I'll hold for just a minute here.
Mr. Lilly, this is Lindsay. Even if we do not plan on speaking during this, would you still like us to go on video?
I'm sorry, I couldn't quite hear you. What was that? Please say it again.
Oh, if we're not going on, if we don't plan on speaking, would you still like us to put up our video?
No, you don't have to. This is just mainly for the participants. I mean, if you're just listening in like a member of the audience and you want to be just on audio and watch the rest of us, that's fine.
Great, thank you.
Yeah, you're welcome. Sorry, we're still learning all of these procedures, so just bear with me as we go forward, and we'll do the best we can. And it looks like we have a couple of just phone numbers, so I'm not sure who's there. So we'll go ahead and get started and see if everybody's on board. First of all, I am Alan Lilly. I'm the presiding hearing officer of the Administrative Hearings Office. And we've all talked before, so I think you're probably pretty familiar with our office and what we do. Today, we will not have a court reporter, but we will be recording the meeting, both video plus audio and audio only, and we will post those files of those recordings to the FTP site when available. So with me on staff here at the Administrative Hearings Office, Nicole Mullen, Kyle Woldridge, and Skylar Anderson, and Megan Nyes, another hearing officer who just joined our office. And then also helping me and them with our technical assistance, we have Amy Blunk from the Division of Water Rights and Carol Berkeley from the Office of Chief Counsel. And you might wonder why we have so many people. And the answer is we're all still learning how to do these video hearings. And frankly, their expertise, particularly from Amy and Carol, is very much appreciated as we go forward. So with that, I'm just going to first go down the names of the attorneys I have to make on my list to see who's here. So David Rose, I think I saw you there. Mr. Rose, are you present?
Present.
Okay, and
good morning.
Good morning. And Jennifer Spalletta, I see you. Good morning.
Morning.
And is Dean Ruiz on?
Yes, I am.
Oh,
Good
so
morning.
Mr. Ruiz, are you the 209 area code?
Yes.
Okay, it's 209 and then it's blanked out in 148, and that's fine. I wasn't clear on whether or not we were doing video plus audio or audio only, so that's fine. When we get to a hearing, obviously we'd like to have everybody by video, but that's fine for today. And is John Herrick participating today?
Yes, I am, and Dean and I are both on the same line here.
Okay. Great, thank you. Good morning, Mr. Herrick. And then I think I saw, yes, Rebecca Ackroyd, you were there. I see you. Good morning.
Morning.
And is there anybody else who would like to participate today? Certainly observers are always welcome. This is a public proceeding, but is there anybody else who would like to participate besides the people who've already spoken? Okay. Hearing none, we'll go forward. I don't think this will take a super long time today, but first of all, I do appreciate you all taking the time this morning for this conference. You know the process from last time. Just works easiest for me to do most of the speaking, and I'll call on people, but I'll try to pause from time to time, get drinks of water and things like that. So, but please speak up, and if you need to say something and I'm not stopping, just feel free to interrupt, and that's fine. We have to do the best we can doing this all by teleconference. I do ask, I noticed most of you are doing this, please keep your microphones on mute when you're not speaking. Sometimes we have feedback problems if people are not on mute. And if necessary, if I haven't just called your name regarding a question, please say your name when you speak, just so we all know who is speaking. Frankly, with the Zoom display, it's a little bit simpler, but that still would be helpful. So, and as I said, we're all still learning, so please bear with me as we go forward. Before we get into the substance, does anyone have any questions or comments about the process we're following today? Okay, hearing none, we will go forward. And just by way of background, I know most of you probably have your files and this is all obvious, but I just want to make sure we're all on the same pages, so to speak. On March 11th, this office issued our first notice of status conference in these three matters. We held the status conference on April 17. On May 15, I issued a status conference order and a notice of this pre-hearing conference. There was a joint request for continuance filed on June 1st, and then I sent a letter denying that request on June 5th. On June 8th, the prosecution team, through Mr. Rose, filed and served revised draft cease and desist orders. And on June 26th, all of the parties filed their status conference statements. So having considered that background, let me just tell you, this is sort of like a tentative ruling, but I have some ideas. I was giving this some thought last night and this morning, and I have some ideas about my assessment of the issues and how I propose to proceed. So let me tell you that, and then I'll certainly be glad to hear comments from all of you on my proposal and whether or not you think it's appropriate or should be changed. So first of all, regarding the first four status conference issues, and these are listed on page 2 of the May 15th status conference order. Issue number 1, what is the status of the parties' discussions of and potential narrowing of the pending issues? Based on the status conference statements, my take is that the parties have had some preliminary discussions, but not a lot. And I'll just say, it appears to me that the parties may or may not be able to narrow the pending issues. Certainly at this point, I think it's appropriate for us to proceed with scheduling the hearings. And obviously, if the parties can reach agreement on any or all of the issues, that's fine. Certainly I have no problem with that. But I'm going forward off the assumption that the parties are not going to be able to resolve at least some of the major pending issues. Regarding issue 2, what is the status of the parties' exchanges of the relevant documents? It appears that that is ongoing, but has not been completed. And we can talk about that as necessary. I think I have a proposal that should be able to address that, at least to a large degree. Issue number 3, will the parties be filing a stipulated set of exhibits for the hearing? At this point, it does not appear to me that the parties are likely to be doing that. I just don't think there's going to be time. Maybe if you had more time, you could reach consensus, but it just seems to me there's too much in flux right now for that to happen. So that was perhaps optimistic on my part before, but I'm not expecting that at this point. Obviously, if you can, that's great, but it's not going to be necessary. And then issue 4, is it appropriate to have staggered exhibit filing deadlines with the prosecution team's exhibits being due before the respondents' exhibits? And it appears that everybody agrees that that does make sense here, and it certainly does to me as well. So based on that assessment, here is what I am proposing for going forward. And I'll speak a little more slowly about this because you may all want to take notes, and then I'll ask you for comments. So what I'm proposing, and first of all, we will have separate hearings. It's convenient to have this one pre-hearing conference for all of the matters, but there will be, basically we'll split this into separate proceedings for each matter. So there will be separate filings and so forth. Obviously, any of you can listen in to any of the hearings, even if it's not a matter you're a party to. So what I'm proposing is that the exhibit filing deadline for the prosecution team exhibits will be September 11. Mr. Rose, in his status conference statements, had proposed September 18. I'm just proposing to move that up 1 week, just sort of so we can fit everything into the schedule I have here, mindful that before we know it, it's going to be Thanksgiving and the December and January holiday season, and hopefully we can get the hearings wrapped up before then. So with that date, that would give the prosecution team almost 2.5 months from today to prepare its exhibits. Obviously, this is a matter the prosecution team has been working on, at least on and off, for the last 10 years. It's not new, and it certainly has geared up considerably since March. So I don't think we're starting, the prosecution team will be starting from scratch, and that is 2.5 months, which to me seems like sufficient time. Then the exhibit filing deadline for the respondents in each matter will be October 26th. That will give the respondents about 1.5 months to review the prosecution team's exhibits and to prepare and file the respondents' exhibits. And almost 4 months, I'll note, from today to prepare those exhibits. And certainly the respondents can be doing a lot of work on their exhibits before receiving the prosecution team's exhibits. And obviously, each respondent knows his, her, or its situation and the applicable legal documents and so forth. So you certainly don't need to wait to get the prosecution team's exhibits to start preparing yours. And the main purpose of the staggered filing deadline is just to really to give you a chance to refine your exhibits so that they can be responsive to the prosecution team's exhibits, which will presumably set out the prosecution team's arguments and what I'll call their theory of the case. And then number 3, the hearing dates will be on various days in November with a separate hearing date for each matter. And we'll talk with Ms. Spalletta as to whether or not the Eddie Vierra Farms matters should be split into 3 different matters, and with Mr. Rose, of course, as she has proposed. The hearings, at this point, I am assuming the hearings are all going to be by teleconference using Zoom. It seems pretty clear we're not going to be going back to the Cal EPA building full-time by November. At least at this point, it appears we're going to be working remotely as much as we can. And frankly, I think we all have developed pretty good experience to do hearings by Zoom. It's a little bit trickier, but you're all experienced and talented attorneys, and with witness preparation and with my extremely talented staff to make sure exhibits are up on the screen and so forth, I think we can go forward. So that's certainly my plan at this point. And what that means is the dates I'd been given before were the dates when hearing rooms were available. And since we don't need a hearing room, we now have more flexibility to pick dates in November for those hearings. So that's my proposal. We'll circle back to exhibits or go on to issues 5 and 6 and anything else later on. But I do want to pause here and first ask all the attorneys if they have any comments on this proposal for the pre-hearing and hearing schedule. So Mr. Rose, I'll start with you since you'll have the first exhibit filing deadline. Do you have any comments on this proposal?
No, I don't think so. I do think that depending on what hearing dates you choose in June, it would be, November, same thing. What hearing dates you propose for November, I might have some concern about October 26th being unduly close to the initiation of the hearings. The prosecution team has already laid out its theory of the case in the draft cease and desist orders and the amended draft cease and desist orders. So I certainly don't want to prejudice any of the parties by not having enough time to review the actual documents. But in essence, the documents are going to be coming more from the respondent parties that would defeat the prosecution team's theory or claim of the case that there is not a maintained basis of right for these parcels. And so I have some concerns that the amount of time between October 26th and whatever November dates we choose may not be sufficient for the prosecution team to go through the undoubtedly voluminous records that we will get. Now, we have gotten materials. I don't know if it's all materials, but we just got I think, large number of materials for the Speckman and Ohm matters, and we had already gotten materials for the Vierra matters, which may obviate my concerns, but I wanted to highlight them right now on the off chance that there would be, in essence, surprise exhibits that if we had beforehand would be relevant.
Okay, well, that's certainly a valid concern. And so I'll ask the other attorneys about that, whether they expect to be providing docs to you ahead of time or whether there will be new documents that they would be filing with their time, and then we'll see. But I certainly understand what you're saying. You wouldn't have to prepare any new exhibits, but you're saying it may take you some time to prepare cross-examination questions and potentially rebuttal evidence and questions in response to that. That certainly is a valid point. I certainly understand that. So we will circle back on that. So Ms. Spalletta, I'm going to go to you next, since you're representing Eddie Vierra Farms and you've proposed 3 different hearing dates for the 3 different properties. So do you have any comments on this proposal? And you do have to go off mute, just as a reminder.
There we go.
Yes,
I do
good.
think it's going to be
And
very challenging.
you can just speak up a little bit. You're a little hard to hear.
Sure. This is Jennifer Spalletta for Eddie Vierra Farms. I do think it's going to be very challenging to have hearings on all 5 properties close together in November. And we do feel very strongly about having a separate hearing for each of the 3 Eddie Vierra Farms properties. I think it'll become evident when the hearing officer and staff see a map, but these 3 properties are in 3 different locations on Roberts Island and have completely different chains of title and completely different parties in the chains of title. So it's like 3 separate CDOs, frankly. And so I think it would be really, really confusing to try and do them all in one hearing. Frankly, the historic evidence is hard enough for one at a time, but when you try to put it all together at the same time, it would be very confusing. So we would definitely want to have at least the ability for the prosecution team to put on their case in chief for each ranch. We would put on a responsive case, any rebuttal, and close that ranch before moving on to the next one is how we'd want to proceed. As far as scheduling them serially, there is some similarity between one of the Eddie Vierra Farms properties and the Speckman Ranch. They are adjacent to each other, so I think it would make sense to schedule those 2 in proximity to each other. There will be some common exhibits and probably will reduce confusion for everyone if we're able to do that.
I'm sorry, I couldn't quite hear you. Which ranch is that's adjacent to the Speckman property?
We call it the home ranch, and I believe
Okay.
the prosecution team knows which one it is, but that is the one that I would say would be logical to have close in proximity to the Speckman hearing. So we would maybe do Speckman first and then Eddie Vierra Farms home ranch second. Is
Okay.
how I would propose it. I think that will be the most logical. As far as the timing, I don't think that there are going to be any substantial new documents that will be a surprise to the prosecution team at the end of October, at least from Eddie Vierra Farms. We will have a historian who will analyze the extrinsic evidence, historic extrinsic evidence for the relevant deeds, and he will provide written testimony. And he, of course, is looking for additional extrinsic evidence that we were not able to locate when we responded to the original CDOs quickly in 2010. So there may be some additional things that he finds, which we, of course, would provide to the prosecution team when we find that they're relevant. So I don't think there will be any surprises, but he will have obviously like a report or written testimony that comes in as an exhibit when we file in October. At this point, one of our biggest challenges is we don't have anything substantive from the prosecution team to narrow the issues. And so it's like we're all kind of working in a big mass of documents over a long period of time. So I'm hopeful that we will hear from the prosecution team very soon in response to our discovery, so that we know what the basis is for their conclusion, and we can at least narrow the time frame that we're talking about. I mean, as the hearing officer knows, we're talking about 150 years worth of chain of title. So we need to narrow the time frame to have a meaningful discussion and a more efficient hearing.
Okay, well, thank you. That's very helpful. And I'll say that I certainly hope, as I mentioned during the last status conference, that you will continue to have a good dialogue with Mr. Rose and his team. I mean, I know you're both very competent and professional attorneys, and while representing your clients, can work well to exchange information and documents where appropriate. So obviously, I hope that will continue. But I'll just say, from my point of view, the idea of the staggered filing was sort of a backup, because that gives you, presumably on September 11th, you will have a very good idea, or after you read it on September 12th, you'll have a very good idea of what the prosecution team's evidence is and arguments are. So that will be sort of, I'll just say, the ultimate backup. But obviously, to the extent you and Mr. Rose can exchange information, again, I'm not asking you to waive any arguments, but just be professional about it, as I know you both are. I think that'll be very helpful. So before I go on to Mr. Ruiz and Mr. Herrick, I do want to just circle back to you, Mr. Rose, and ask you, I didn't ask you this before, but do you have any objection to splitting up the Vierra Farms matters into 3 different hearings?
No, I think that Ms. Spoletta's characterization is a good one. As long as your office, the Administrative Hearing Office, has no problem with records or maintaining separate records for the proceedings, which I don't anticipate to be an issue, simply because I think at the end of the day, the actual records for the draft CDO are likely to be merged as one for the Eddie Vierra Farms, unless you dispose of them differently. That would be our primary concern, because the way we crafted this was that the single common owner was to be issued a draft cease and desist order for all of the parcels that were owned by that common owner. But as a matter of hearing, I have no reason to disagree with Ms. Spoletta's suggestion, and think it's probably a good one.
Okay.
Sorry if that's not. Sorry if that sounds somewhat equivocal, but
No. It's actually not equivocal at all. It's very clear.
Okay. Yes, Jennifer. Good.
Okay. So I will proceed that way. I mean, with both of you in agreement. Obviously, it makes sense to me as well. We will notice. It's going to be a little more noticing work for us, but of course that's appropriate. We will notice 3 separate hearings. So, and basically, we're going to split the Vierra Farms matter into 3 separate proceedings. So there will be a different set of exhibits and a different hearing date for each one. Now, whether or not at the end of the day, that the Administrative Hearings Office will prepare a proposed order, which, as you know, under the law, we transmit to the board members for the board's consideration. Whether or not at the end of the day we have one proposed order for all 3 Vierra Farms properties or 3, I don't know. And I don't know that, I mean, we certainly don't need to decide that now. At the appropriate time, I'm sure we will have closing briefs in these matters, and that's something that both of you can address in your closing briefs. I'm not sure it makes a huge difference whether there's one order with 3 parts and presumably 3 different sets of conclusions, or whether there are 3 separate orders. But if anybody feel strongly about that, that you can address that in your closing briefs. I don't think there's any need for us to resolve that now. And we certainly can have 3 separate hearings and then end up with one order. That there's no legal impediment to that. So, and Ms. Spalletta, I did note, and unless anyone else has an objection, that you proposed that the hearing on the home ranch matter proceed right after the hearing on the Speckman matter. And unless anyone else has a problem with that, I don't know enough to know one way or the other. So that certainly makes sense to me. And then perhaps because of your I'll just say workload concern, having to prepare for 3 different hearings, we may have Speckman and then home ranch and then have the Ohm hearing and then circle back to the other 2 Vierra farms to give you a little more breathing room. I used to be an attorney putting on cases before the water board. I know how hard it is to get everything ready. So I certainly understand for all of you what you need to do to prepare cases. It's a lot of work, and frankly, it's in my interest that you're as prepared as possible because it makes the hearing go more smoothly. So I'll go on to Mr. Ruiz and Mr. Herrick, and then we can circle back, obviously, if anything else comes up. So Mr. Ruiz and Mr. Herrick, whichever one of you wants to talk, and you can talk about Speckman, or why don't you start with Speckman since Ms. Spalletta has brought that up, and then go on and give your comments for Ohm after that.
This is John Herrick for Speckman and Ohm, and I'll just give you the bitter, angry view from my perspective. I'm a little confused on why we're proceeding like this. As you well know, the Tanaka hearing, which dealt with similar issues, the historian that we hired, which is the same one for here, it took him over a year to do a comprehensive summary or scan or survey of the relevant documents to try to find information to present his report. And we informed the hearing officer that, at the minimum, he needed through the end of the year. And now we're taking 2 months off of that. And I don't think that's possible for him to go through the necessary materials to find the evidence of activities and farming on the land, which is necessary to present a case. The notion that we're moving forward is very confusing to me. The prosecution team failed to note to you in their status conference statement that they lost all the files after a certain point. So the information that was provided by my predecessors to the prosecution team trying to address these issues is gone. Now, I just learned yesterday, contrary to what I put in our status conference statement, yesterday I learned that there were responses from the state board or the staff. I don't know what those say yet. They've been sent to me. And the staff, the state board prosecution team certainly doesn't know what's in them because they didn't reference them or how they may have affected their analysis. And then finally, I have to go back to the Tanaka case, which we're all intimately familiar with. And if the prosecution team would like to sit down and identify the deeds that sever the properties from surface connection to waterways, and then check those deeds to see the language has that same tenements, hereditaments, and appurtenances, then this should all go away. If it doesn't go away like this, then we're forced to spend upwards of $100,000 or more in the next 4 or 5 months to accomplish nothing, because we already have law that says that phrase in 1890 means it includes riparian rights. So I'm stymied that we're proceeding on this sort of expedited manner after the CDOs have been at rest for 10 years with no activity, and the client's lands are the titles are slandered. I'm just amazed that this is what we're doing. So those are my comments. I don't know if Dean has something else too.
All right, Mr. Ruiz, why don't you give your comments if you have anything you want to add?
Yeah, this is Dean Ruiz. I would join in Mr. Herrick's comments overall. And then moving into, some of the issues that you've already talked about, Mr. Lilly, and sort of your proposal or tentative ruling as you described it. The fact that we all, Vierra, Ohm, and Speckman have the same expert, that really presents difficulty in putting on these cases, being ready for these cases appropriately, all in November. it's a difficult situation to do that. We had proposed in our conference statements that, you know, if we're going to start with Speckman and then the Vierra home ranch, that Ohm and the rest of the properties be subsequent to that, not all scattered or staggered in proximity to each other in the same month or in close proximity. I think that it makes it very difficult for us to put on the case properly, and especially it's a lot on our expert, who at this point it's going to be difficult for him to be ready with a November schedule at all, or an October schedule really. So I'd like that to be considered further, because I don't think there'd be an objection from the other parties if we were to, you know, put Ohm on later as we proposed, or the other in proximity to the other Eddie Vierra pieces, as opposed to everything being in November. And if we were going to start in November with anything, I would request at a minimum that it's at the end of November.
Okay. So Mr. Ruiz and Mr. Herrick, if you can just clarify for me, first of all, and I will ask Mr. Rose to respond to some of your comments. I mean, I understand your frustration about basically, and again, I'm just characterizing it this way. This isn't any conclusion, and don't anybody get too upset. But basically, as I understand it, you're saying you don't have a very good idea as to what the prosecution team's case is. And as I said earlier, my goal on that, by having the staggered filing, is to give you, I mean, the best way for you to know what the prosecution team's case is for them to file all their documents and serve them, and then you can see them, and that will give you the details. But separate from that, and you know, and I don't know, I have no way of knowing right now, and Mr. Rose doesn't have to say today whether or not the prosecution team's case is going to argue that the riparian rights to these parcels have been severed, whether there aren't pre-14 rights, or what. That he did file draft CDOs, which indicates that the prosecution team believes that there's still illegal diversions going on. So since he did that, we need to have a hearing, and we need to get all the evidence and then prepare a proposed order. And as I say, I have no idea right now whether or not I will agree at the end of the day that there are unauthorized diversions or not. Just don't have any way to know right now. But we do need to have a hearing. The fact that it's dragged on for 10 years, from my point of view, means we ought to get moving, not that we ought to have it drag on for more time. And that certainly is the instruction I've received from Joaquin Esquivel and the other board members, that we need to basically get water rights being administered in California. And you know, and frankly, your concern, you mentioned a slander on the title of the property. Well, obviously the best way to resolve that issue is to have a hearing and get an order out. So those are my general thoughts, but I would like to get one clarification from either Mr. Herrick or Mr. Ruiz about your expert. And I understand what you're saying about it's hard for one expert to do work regarding 5 different properties. You know, and I understand it's both reviewing historical title documents and also evidence of historical use. But what I don't understand is you've known about this matter at least since March that we were going forward. And, you know, since the middle of June, you know that there are new draft CDOs, and you certainly can start the expert's work now. I mean, yes, Mr. Rose's filings will give you some additional detail, but as you alluded to, Mr. Herrick, I think you know pretty darn well, you're going to have to prove that riparian rights exist or that pre-14 rights exist at the end of the day. So you don't really need to wait until you see Mr. Rose's exhibits in October to start doing that work. So can one of you just clarify why 4 months to do that work is not sufficient for your expert?
Well, this is John Herrick. Let me just clarify that we've been talking to our expert for over 2 months now. So we haven't been sitting around waiting for nothing, but we were told by everybody who's on this phone call that once the Tanaka decision is final, then we can resolve these issues. Now, nobody guaranteed anything. We can't rely on that. I can't sue anybody for lying to me. But that was the understanding. And then 2 weeks after the Tanaka decision, somebody says, well, you know, it looks like they're going to appeal it, and then everything is off. Suddenly, there's no effort to resolve these issues. The expert has to scan through literally thousands of editions of not only journals and periodicals, but newspapers. And he has to search for the names of everybody associated with the ownerships of these properties immediately before 1914 and after that, in order to try to find information that has to do with water use on the property. And again, we went through this once before. You weren't involved in that. It was the court case. This took him over a year to do one property. And the notion that he can do whatever, we have 5 properties here and look for all those, you know, I don't know, maybe it's 50 names now instead of 3 or 4. It's unrealistic. Now, what I want to say about all this is we know what the prosecution's case is generally. They don't have any case. They told you in their status conference that they looked at maps and aerial photograph and said this property isn't connected to the waterways. That's not a case. And so we've offered numerous times to sit down with the prosecution, show them the severing deeds, show them why we think those are the severing deeds, and show them the language in that, and we have nothing. And so I don't know how you can produce a CDO that accuses our clients of being illegal diverters when you haven't done any research. And we're offering to give you the information that, according to the Tanaka ruling, settles the cases. And so I don't know why somebody wants to expedite these hearings. Of course, we would like the titles to no longer be slandered, but we want it to go away. If the prosecution can find something someday that accuses us or has any evidence, that's fine. If Tanaka gets overturned in 2 years because it goes to the Supreme Court, fine. But these should be dismissed. It's up to them if they want to do it without prejudice. But there's no case here. The prosecution team looked at maps and said these properties aren't connected to the river and they don't have a license. That's not a case. And I shouldn't have to spend hundreds of thousands of dollars to satisfy the State Water Board's eagerness to prosecute Delta water users. And we're really not happy about this. I don't blame you, Mr. Lilly, but this is ridiculous. 10-year-old, and all of a sudden now I'm supposed to have done research for the past 10 years when I was told I didn't need to, because if Tanaka ruled one way, we'd be okay. Well, now we're not okay, so we're stuck.
Okay, well, so that I certainly appreciate your explaining your views on this. And just to clarify, I'm not, when you said about what people said about Tanaka, all I know is what I said. And what I said during the last pre-hearing conference is we needed to wait until the Court of Appeal issued its decision, and then we'd have another status conference or pre-hearing conference to decide how to proceed. I certainly never said anything more than that, because I wouldn't have enough information to say anything more than that. I still don't. So I just wanted to clarify
Mr. Lilly,
that.
I'm not accusing you of anything. I'm not accusing anything, but
Okay, that's fine. Thank
and Mr. Rose know that we talked about this, and they said, look, we're not going to do anything. We'll make a decision once Tanaka comes out. Well, that means that if Tanaka's in our favor, a decision would be in our favor. And instead, they just decide to, well, we won't make a decision now. And they want to move forward based upon the old CDO and based upon the records that they lost, which obviously they haven't reviewed. I assume if you lost the records, you haven't reviewed them to issue this CDO. So
Okay.
This is just abominable to me.
Okay, I understand your view. So Mr. Rose, you know, and we're not getting into the merit, or I'm trying to avoid getting into the merits today. I'm not in a position to really evaluate the merits. I don't have enough information. I don't have any evidence beyond, you know, just what's in the draft CDOs, which isn't evidence, of course, just allegations. So Mr. Rose, you did file new draft CDOs, which certainly indicated to me that the prosecution team wants to proceed, and you certainly have a right to proceed and to have a hearing. So do you have any responses to Mr. Herrick? And again, basically, whatever you want to respond to his comments, but what I'm most interested in is what's an appropriate hearing schedule here.
Sure, thanks. I don't feel the need to respond to most of his points at this particular juncture, although I'm happy to talk to him separately about many of those things. What the prosecution team has done is filed amended draft CDOs on the schedule identified by the Administrative Hearings Office and followed the due dates, timelines identified by the Administrative Hearings Office. We agree with counsel for Ohm and Speckman, and presumably the counsel for Vierra, that part of the assumptions that went into the I don't know if delay is the right word, but the passage of time have been that Tanaka would be relevant, the decision in the court case, Tanaka would be relevant to these proceedings. We reviewed the Tanaka decision and stand by the reissued draft CDOs. However, we do agree that, and we did request further time to engage in settlement discussions and to talk about alternative disposition of these matters with the respondents. And of course, your office determined, as is your prerogative, that these should proceed to a hearing. So I wouldn't be alone in renewing a request to have more time to have settlement discussions or alternative disposition of these matters to apply the facts to the law. Tanaka is new. I don't view it as a thumbs up, thumbs down answer to every question in my read of it. But again, the prosecution team did reissue the amended draft CDOs, cognizant of Tanaka and the facts in front of us, and will proceed on the schedule that's set with our cases. But if you're willing to consider more time for discussions, whether it's separate time or just simply whatever schedule the respondents ask for to get their exhibits together, we will use that time to engage in settlement conversations if the parties are willing to do so, hopefully fruitfully, and possibly obviate the need for hearings. But I can't say at this point whether that would come to fruition. I know that we've dealt with a number of the same counsel, myself and the counsel for the other parties, on similar proceedings in the past, and could do so again to at least see where those conversations could go.
Okay, well, thank you. And I appreciate that explanation as well. And I'll just say from my point of view, you know, as you all know, I was a lawyer representing clients with water issues for, I'll just say, several decades. And so I understand not exactly, but I understand in general terms what you go through. And I certainly understand the tension between, on one hand, trying to settle a matter, and on the other hand, trying to prepare a matter for hearing. I was there many times myself, and so I get that. But I just want to say, from my point of view, there are two factors that are really affecting my decisions here. And if I've made your lives miserable, I apologize, but maybe that just goes with the territory of being an attorney in this business. I mean, for all of you, but the two factors that are affecting me are, number one, as I mentioned before, when I first started this job, which was last November, I did meet with all 5 board members. Of course, I'd interviewed with them before they decided to hire me for this job. And the number one overriding message that the board members gave me, and it's all the same 5 board members who are still on the board today, is we need to move things along. Water rights in California are just sort of at an impasse. Things are stalled. We need to move forward. That's been a very clear, consistent message. So as matters are assigned to me, and these basically came to me to my office by operation of law, I take it that my instructions are to try to get things resolved as promptly as I can. Understanding, of course, the logistical issues that the attorneys for the parties and the parties' witnesses need to go through. So that's my consideration number one. Consideration number two is based on my experience. Settlements happen for different reasons and don't happen for different reasons. But one of the reasons settlements happen is when people have deadlines for either settling or facing the consequences if they don't settle, in this case of going to a hearing. And frankly, when I read your status conference statements, and I'm not going to accuse anybody of doing anything improper or who's what or anything like that. I don't have enough information to get into that. But frankly, your settlement conference statements were all fairly equivocal on time for, optimism for settlement, time for the settlement process, and anything like that. And I'll just say my reaction from reading all of them is I need to set a hearing schedule to give the parties a framework so that they can understand what they're operating under. I understand that means you have to dual track between settlement discussions and preparing for hearing, but that's just sort of the name of the business, or the name of the game in the business of frankly, any litigation, and certainly for water rights. So I get that. So I will say, as I said before, the prosecution team has indicated it still thinks that it does want to pursue draft CDOs, and obviously therefore thinks it has some viable arguments. The respondents obviously disagree, and that's exactly what hearings are for, is to receive evidence, receive argument, evaluate it, and in this case, issue proposed orders. So that is why I'm going forward. I mean, frankly, if I had just said, come back in 6 months and let me know where you are, I'm afraid I would be getting a report a lot like where we are today. Maybe not, but that was my concern. So that's why I've decided we need to go forward with a hearing schedule. Now I am, Mr. Rose has set forth that he's acceptable with my proposal for a September 11 filing deadline for the prosecution team exhibits, and I certainly think we should do that, because that will frankly help the respondents get a very clear picture as to exactly what the prosecution team is arguing. I suspect by then that the Supreme Court will have ruled on the Tanaka petition for hearing. If the Supreme Court, in the unlikely event they grant a hearing, we'll have to talk about whether or not this process or schedule should be revised. But if they deny the petition for rehearing, issue will be resolved, and that it's targeted for the middle of August right now under their normal schedule. So that's where I am. What I'm hearing today from the respondents' attorneys is you're somewhat concerned about the October 26th proposed date, and then also about having hearings, both because of the time to review the prosecution team's exhibits and having one expert having to prepare for 5 different hearings. So I will talk with my colleagues at the Administrative Hearings Office, and we will discuss whether there should be any changes to those schedules. As you all know, the holiday season gets to be a difficult time. That's why I'd hoped that we could have these hearings before Thanksgiving, because after that, people schedule, people have family issues and other matters, not issues, but times they want to be together and other constraints on schedules. So it gets to be hard, and I just hate to lose another 2 months and suddenly have hearings in January. But I will talk that over with my colleagues internally, and we will decide how to go forward, both with the exhibit filing deadline for the respondents and for the hearing dates. So before I move on, I've rambled on a bit here. Just, you don't need to repeat yourselves, but is there anything else new that anybody would like to say? And Ms. Spalletta, I haven't called on you most recently, so I'll start with you. Is there anything new that you would like to add on any of these issues at this point?
I do have 2 things I'd like to add. Number one, I can appreciate your position in wanting to move these along to completion. And I think, frankly, my client wants them to be completed. I do have a couple of suggestions. One is that one of the reasons that our expert is going to be so busy and it's going to cost so much is because we do not have some very basic information from the prosecution team that would allow us to narrow the scope of the research. And it is my personal belief that they should not have filed CDOs without having written findings from their investigation. And it's an improper pleading because they cannot plead a prima facie case to meet their burden of proof. But we have tried to give them the opportunity to cure that defect, which would also help narrow the scope of the historian's research by asking them to either amend the CDOs to provide the specificity for their findings, which is not in there now, or to respond in a timely manner to our written requests for information, which frankly are very basic. You know, what do you claim is the severing deed? What extrinsic evidence do you have related to that deed? Pretty simple questions. We attach them to our joint filing. And I think if you as the hearing officer could direct them to provide a timely response to those, it will resolve some of the concerns that Mr. Herrick addressed, which are very serious and financially big concerns for our clients. The second thing is we have 5 of these that are going to have, I believe, if my suspicion is correct, are going to have deed transactions with very similar language and potentially very similar historic circumstances. So one of the things I'm a little concerned about is having 5 probably full-day hearings with a lot of time and resources spent, and then having you as the hearing officer issue the first decision and potentially finding, let's say, in favor of the respondent, and your reasoning would be equally applicable to the next 4 properties. And I think all of the parties and frankly the hearing team might benefit from you reaching a decision on the first one before we actually go to hearing on the next 4. Because if your decision is going to be more or less dispositive of the next 4, I don't think any of us want to have wasted all of that time and money in preparation and hearings and so forth if we could, as a result of the first decision, reach a settlement on the next 4. So just something to keep in mind for efficiency's sake. You know, I know that, like I said, these are all different in some respects, but your rationale for deciding them might end up being consistent. And I don't want to go through 5 hearings only to have the first decision be dispositive of the next 4. So something to think about in the schedule.
Okay, well, that certainly is something we will give some consideration to. I'll just say, probably stating the obvious, but I'll say it anyway. I don't issue decisions, I don't issue orders in these matters. All I can do is, all I'm allowed under the statute is to prepare proposed orders, which then go to the board for consideration. The board normally has 90 days to act on those by law, although there are certain circumstances where they can extend that, and they can also send it back for further proceedings. So that's, again, something that could draw out the proceeding quite a bit. And of course, then there can be court review of the board's final decision if some party is not satisfied with what the board has done. So that is a concern that could cause this to, again, draw out further. I had actually thought the opposite, that we would have all 5 hearings and that my office would prepare all 5 proposed orders and send them to the board as a package. I mean, the board, of course, has to act on each one individually, but they certainly can consider them all at the same time. So that, I mean, I understand what you're saying. That would be a lot more work for all the parties, including the Administrative Hearings Office. But that, I think, is what the board, in some ways, that's the best for the board. Then they have everything to consider at one time, and it can all go forward. But I will consider your comments, because I mean, it's certainly what you say has some merit, and you know, there are trade-offs, but that certainly is a valid comment. As far as your first question, before I go on to Mr. Ruiz and Mr. Herrick, I want to turn to you, Mr. Rose. Ms. Spalletta just said, and I'm paraphrasing, so if I get it wrong, I apologize, but basically, she thinks that the respondents' process, both for settlement and for preparing their exhibits and testimony, can be made much more efficient and focused if the prosecution team responds to the document requests and information requests that the respondents have served on the prosecution team. And so do you have, and again, I'm a little wary of getting into this because I'm not a court, I'm not a judge, I don't have the authority to issue discovery orders the way judges do, although I think I do have some general authority to issue orders administering my hearing processes. But Mr. Rose, what is your plan on responding to the information and document requests from respondents?
Yeah, we expect responses to go out imminently to each of them. What we've been doing is going through the documents that we have and organizing them to make sure that we can send out a complete set to each of the parties who requested them. So I can't say at this time to what degree we intend to do, in essence, interrogatory request type responses, but we're certainly planning on sending out all the documents in very short order. So hopefully that will assist everybody with regard to the questions that are going to be in front of you. So that may or may not answer your question, but I was going to make another point, and I'll wait until you are satisfied that I've answered your question at least.
No, that's fine. And again, just kind of to try to give some structure to this pre-hearing process. Today is July 1st, so would you have any objection if my order directs you to prepare and serve those responses by July 15th? 2 weeks.
I'd have to talk to my client because we've been going through everything. I think that they are probably all ready to go out in advance of that, if not this week. But in terms of adding on service obligations with specific, proof of service and things like that, things that are generally best accomplished by a person in an office where those things are, we'll have some additional difficulties if there's additional process laid on top of that. We're also talking about, as has been made clear, 5 different ranches. So I don't want to commit. Michael George has unmuted himself, and I'm happy to let my client weigh in on that particular question.
All right, Mr. George, I see you've unmuted and gone on camera, so please add any clarification you would like on this point.
Thank you, Mr. Lilly. I agree with, obviously, David, that we're going through it, organizing it. We should be able to provide those documents, I hope, prior to the 15th. But I'm not certain, particularly because of the difficulty of getting into the office and getting the physical hold of those documents. We're far along in that process, and I think we'll be able to get them out by July 15th. That's certainly, we're trying to do it more quickly than that, but I don't think on behalf of our office staff that I can commit to that today.
Okay, and excuse me, my home phone is ringing, but don't let it bother you. This is one of the challenges of working from home. Well, I think it'll just go off in just a minute, sorry. So I do think having a scheduling order will help here. So I'm going to look into a date for that, just because I think Ms. Spalletta made a pretty valid point that and it bears on somewhat on what Mr. Herrick said as well. It'll certainly help the respondents know a lot more detail about the prosecution's case. So I think having some deadline for that would be helpful. And then just to clarify, those are basically discovery matters, so they will not I don't want them filed with the Administrative Hearings Office. They're not exhibits. You all, prosecution team and respondents, will have to decide which documents you want to file as exhibits and so forth. But I do think having some structure here with some schedules makes sense. And, and frankly, I think Ms. Spalletta made a pretty darn good point that those docs will help in advance of a September 11th filing deadline. Those docs will help give the respondents more information to start preparing their responses. So thank you all. Thank you, Ms. Spalletta, Mr. Rose, and Mr. George for clarifying. It looks like you're raising your hand, Mr. George. What have I missed? Go ahead.
I believe that both respondents have suggested specific dates for those responses and asked for an order that we provide the documents by those dates. The dates that the respondents have requested we think are reasonable. We have been preparing to respond within those dates. So if you're going to set a date, which I respect and understand, I would respectfully ask that you take the dates that the respondents proposed.
Okay, can you just tell me what those are? Okay, here, Eddie Vierra Farms, I'm reading the joint pre-hearing conference statement from Ms. Spalletta and Mr. Rose on page 3. Eddie Vierra Farms requested the hearing officer direct the State Board to fully respond to requests on or before July 18. So thank you very much. I'm not going to make it before that if the parties have, if the respondents have agreed to that. And Mr. George, is there a similar date in the other two pre-hearing conferences?
Yes, I believe the date in the other two are for the 23rd of July.
Okay, Mr. Herrick or Mr. Ruiz, let me just double check. I'm filtering through here. Is that correct?
The date, this is John Herrick. The dates mentioned by Mr. George are correct. We have nothing wrong with Mr. Rose's commitment to do them imminently, and I think that would faster the better. And I'm a little confused as to how they can review the documents, but they can't copy them and send them off. So somebody has control of the documents. They're not hidden in a safe somewhere. So the sooner the better. Before
okay,
the
thank you.
request,
Yeah, we'll get back to you, Mr. Herrick. I do appreciate, I had sort of just pulled July 15th out of the air, and I apologize. Certainly, those dates that have been proposed, and Mr. George, thank you. That certainly makes sense to go with those. I'll just say, Mr. Herrick, I don't work with Mr. Rose or Mr. George. I don't go into the building at all anymore, so I don't even see them. But I'll just say we are having a lot of challenges with getting into our building and doing things logistically. So, I mean, I know it's frustrating for all of us. I think we all kind of wish we could be back in the good old days when we could just all work and get things done with staff coordination and so forth. But it's a challenge, but let's try to stick to those deadlines for those responses. I will include those in an order just under the general authority that this office has to administer the hearing process. And frankly, that should help move things forward. So,
Mr. Lilly, can I ask
please
a question?
Go ahead. Go ahead, Mr. Rose, please.
Yeah, I just wanted to be clear that I was understanding what we were talking about, because what I think Mr. George and myself have been talking about is providing copies of all documents. And I believe that there were also interrogatory type requests from some of the respondents that would involve newly created work and answers that would need reviewing and further discussion that unfortunately are not exactly easy to pull out of a hat at this stage, the same way that they would have been when the draft CDOs were initially issued. So I can explain a little bit further. We issued the amended draft CDOs based on the information we have and the applicable law on the schedule required by the AHO. But that's not to say that we would necessarily have staff at this point prepared to come up with specific responses as to specific written responses as to some of the additional questions that would be asked of some of the respondents on the time frame that you're talking about. So what I'd request is that if you're issuing an order that we take a certain action, that it be to provide the documents, which is what we've been speaking about and are prepared to do. Further requests for admissions, interrogatories, those types of issues, I would request that they not be set on the same schedule, just because of the difficulties that would present for us.
And what schedule do you propose for those responses then?
At a minimum, an additional 2 weeks to answer those questions. But again, we have new staff coming up to speed on work that was done. And I wouldn't say that our issuance of amended draft CDOs didn't rely on the correctness of the issuance of the initial draft CDOs. So in order to have staff be prepared months before a hearing to answer all questions that are going to come up in a hearing, we'd need more time for that. So in essence, what we're being asked to do is have our entire case prepared and ready to go months before a hearing and before our exhibits are due. And I think that that's procedurally improper or unnecessary. We're happy to do it in the context of settlement and have a sit down with each of the parties. In fact, at the end of this conversation or all conversations, I want to make a separate plug for the expediency that could be gained by that. You know, we moved on into specific topics here, but I think that because of the timing of things, specifically the resolution of the Tanaka matter, if resolution is the right word, but the Court of Appeals decision, and the deadlines for amended draft CDOs coming so close together, are in part what drove our milquetoast joint and separate responses to some of your questions. But I think that there are real opportunities for us to not just engage in settlement discussions, because our experience is different than your past experiences, because these parties have done this together, but also, and possibly more importantly, to reach a stipulated set of exhibits. So I think that may be a worthwhile use of our time for the reasons that Jennifer talked about having to have an expert go through 5 separate sets of hearings. So I can make that plug at the end. I think it's worth considering some brief, modest amount of time, whether you direct those discussions or not. I know I'm getting off your topic here, but I wanted to tee that up, and then Jen raising her hand. But that's what I wanted to say at this point, and get clarity on what you would be ordering the prosecution team to do.
All right, well, thank you. And, you know, normally, I mean, I understand what you're saying. Normally, we don't do a lot of pre-hearing discovery in water right hearing matters. I mean, these are not civil proceedings. We don't have the whole Discovery Act directly applicable. As I said before, I think that the hearing officer has some discretion for conducting hearings, but to order things like that. But I'm hearing you at least an additional 2 weeks for some answers. And I think you're right, Mr. Rose, and I appreciate your professionalism on this, that what the prosecution team can provide will probably help facilitate settlement discussions, as well as perhaps facilitate the respondents, you know, understanding where the prosecution team is coming from and what they should be doing for their exhibits. But on the other hand, we don't normally, it's not like a civil action in court where you basically do have to lay out the whole theory of your case through discovery well in advance of trial. So I think our order from my office will have some deadline for those responses. And frankly, the more information you can provide, I think it's in your interest as well as the respondent's interest to do that for going forward. But I keep coming back, the September 11th date is, I think, again, that's not going to lay out your whole case, but it's going to have to lay out most of it, because you're going to have proposed testimony in addition to your exhibit. So by then, I think everyone will have a pretty clear idea of what the prosecution team is going to do going forward. So, okay, I do want to try to wrap up this discussion. It's been very productive. I think we're getting there. Just again, for Mr. Herrick or Mr. Ruiz, you don't need to repeat your prior arguments. I certainly heard and understood those, but is there anything either of you would like to add based on the recent conversations I've had with Ms. Valletta and Mr. Rose and Mr. George?
Yes, Mr. Lilly, this is Dean Reese. Just real quickly on the discovery issue, I would just point out that our requests are very focused, very straightforward. They really pertain specifically and even cite the reissued draft CDO. So we're not asking for, it's not a grand, broad discovery request. I think I just like you to consider that when you're determining a deadline for not just the documents, but also for the request for information.
Okay, thank you. That I do appreciate that, and I read them over, but I didn't read them over with a fine-tooth comb for exactly that level of detail. So I appreciate that clarification. Anything else from you or Mr. Herrick on this round of discussions?
No, it's John Herrick. No.
Okay, thank you. All right, one question I would like to ask, and I hope you can answer this now. I'm assuming that for each of what now are going to be 5 matters, 1 hearing day, and we can go 9 to 5 with appropriate short breaks, is going to be sufficient. And you've all done water board hearings before, with submitting your witnesses' written testimony in advance, and then just briefly summarizing that. We go much faster than court trials do. And my impression is 1 day of hearing per matter is sufficient, but does anybody have any comments on that? And
Mr. Lilly?
John Herrick.
Okay, Mr. Herrick, you go ahead first, and then Mr. Rose will be second, please.
Sorry, John Herrick here. I think that's optimistic. I don't want to have too many hearing days for each one of these, but having a hearing over Zoom or some other method, I don't know how this is going to go. And the volume of information that we hope to develop and present, I just think that 1 day is not realistic. Sorry.
Okay, that's fine. I want to know now. It's a lot easier to schedule more days now than when we're in November. So thank you. Mr. Rose?
Yeah, I'll respond briefly to your question, but I was going to make a different point. I think that the prosecution team's case in chief, especially if we're separating out each ranch for the Eddie Vierra Farms proceedings or draft CDOs, is likely to be accomplished case in chief in no more than probably 2 hours for each of those proceedings. Cross-examination and the respondents' cases, I can't speak for. I think that 2 days per hearing is probably not unreasonable, but that's just me spitballing. I think so. The other point I was going to make is I don't know if Ms. Aykroyd's fallen off of your list of participants because she hasn't spoken, but she was trying to raise her hand.
No, please. Yeah, Ms. Aykroyd is not falling off. She's right here, and I haven't called on her yet, so we'll go to her at this point. Ms. Aykroyd, is there something you would like to say?
Sure. First, just wanted to clarify that Water Authority, we had submitted an NOI in the Speckman proceeding, but had not submitted an NOI in any of the other proceedings, and so did not plan on engaging in those other proceedings. Second, relating to scheduling, I wanted to note that the Water Authority is still evaluating our role for participating in the Speckman matter, and I don't have any input on the scheduling matters discussed thus far. But assuming the hearings go forward, we may be interested in submitting a more limited policy statement or legal brief as opposed to fully participating in the proceeding. So I would request that when you're considering scheduling, you would consider potentially allowing for limited participation if possible.
Okay, and that certainly, I mean, the hearing notice did allow for policy statements. I know you filed an NOI, but if you want to convert that to making a policy statement, I'm not going to have any objection to that. I don't think any of the other parties will either. It just makes things go a little faster. And frankly, I'm always happy to have more briefing. These are complex issues, and the more briefing from qualified attorneys, which all of you are, it just helps facilitate our decision-making process. So I'll just say right now, Ms. Aykroyd, if you want to just give a policy statement, but then you want to do the work of writing a closing brief on behalf of the Water Authority, I seriously doubt I'm going to have a problem with that. Of course, I may not agree with everything you say, but having more briefing and legal arguments from qualified attorneys is always a good thing in my view. I have to process it, but we can do that. So thank you. So I'm hearing from both Mr. Rose and Mr. Herrick, and I think it's a good point. We did have our first teleconference hearing on June, I think it was 19th, and it was a relatively simple matter, and it still did take 2 hours. So I think Mr. Herrick may have a good point that it may take a little more time to process exhibits, get them up on the screen and so forth. Although I have to say my staff did a very good job before, and I'm sure they, with practice will get even better. So I don't think that's going to be a huge deal. But since we have the luxury of not needing to reserve hearing rooms, I think we'll probably we'll notice one hearing day for each matter and then a second backup hearing day, hopefully the next day or soon thereafter as necessary for each of the matters. And if we don't need the second day, that'll be fine. I'm not going to make you all show up if you've finished on the first day, but I do appreciate that clarification. I think 2 days makes sense. Okay, I don't know, Ms. Spalletta, you didn't get a chance. Do you have any other comments on number of hearing days beyond what I just said? Whoops, you have to go off mute, remember. We're all learning.
I'm still learning. I think we will need 2 for each ranch.
Okay.
Maybe by the end we'll be more efficient, but I think we should start out with 2.
Okay, yeah, I'd rather have a backup day and not use it than have to try to schedule it on the fly. I think that's a lot easier for everyone's calendars. Okay, so we've talked about discovery and so forth. There were some comments in the status conference statements about pre-hearing motions, things like motions to dismiss or motions for summary judgment. I'll just say regarding those, please just remember the statutory context that the Administrative Hearings Office operates within. That was bad grammar, but you know what I mean. We have to prepare a proposed order, which then is submitted to the Water Board for its consideration. So we're not really set up to rule on a motion for summary judgment. I mean, I guess in theory, there's nothing that would prevent us from doing that. Although I'll just say my initial reaction is at the end of the day, I know it's more work for all of you, but unless something is really compelling, we're probably going to want to have a hearing because then we can prepare a proposed order based on having all of the evidence in front of us. Now, I do know that in the past, at least in one example, and there probably are a few, the board has considered and ruled on a motion after the prosecution team put on its case to basically issue a ruling in favor of the respondents before the respondents put on their case. So I'm not saying we won't do that. I mean, certainly if somebody thinks they need to file a motion, I will be glad to hear any motion. Obviously, if a party files a motion and I decide to consider it, then I'll ask the opposing party to respond before I rule. But I just want to alert the parties to the context I'm operating within, and that may make it more limited. We don't have a law and motion department the way superior courts in California do. So that sort of limits what we're able to do. So I did want to clarify that. So I think we've covered everything I had on my calendar today. But I do want to just go down the list for any final comments. I'm not sure who to start with. I guess I'll start with you, Mr. Rose, for the prosecution team. Do you have any other issues or comments that you would like to raise today?
Not especially. I think I'll make a final plug like I had teased. That's probably the wrong word. Promised before that we've heard a lot of different perspectives, and I'll just add mine, that I think from the prosecution team's view, the documents that the respondents have given to us, whether you want to say recently or a decade ago, are probably going to be tremendously significant in terms of stipulated exhibits or narrowing of the facts, more so than I think, and the respondents could disagree, or respondents counsel could disagree, than what the prosecution team could provide. And I would make another plug for something like 30 days or some limited amount of time during which the parties directed or expected to get together and discuss those materials, because Ohm and Speckman, while they gave them to us 10 years ago, just provided those to us in the last few days. And Tanaka, of course, is brand new and lays out a case for going through specific facts and documents in a specific way. So I do think that there would be merit in terms of efficiency for the parties to have a limited, not an unlimited, I hear your concerns very much and agree with them for the most part, amount of time to do the work that we had kind of all expected we would do once Tanaka was resolved. But, and this is not in any way casting blame, I understand your charge and goals and perspective, but we haven't really had an opportunity to do that since Tanaka was decided. We've been a little bit more, as you could probably see from the submittals that we've all made, in a different posture after the Tanaka decision came out than we expected we would be, having waited and waited for the Tanaka decision for quite some time, expecting it would be relevant. But some limited amount of time, perhaps 30 days, for the parties to get together with the information that the respondents have provided to the prosecution team, obviously not sitting in the same room, but maybe a Zoom call, something where would provide tremendous efficiencies, I think, in terms of narrowing the scope and possible joint submittals of exhibits. We've previously been discussing this as a matter of settlement, but I think that you could also just as appropriately look at it as a matter of joint exhibits or stipulated exhibits and narrowing the scope, because those things may very well be possible. I won't say it with the same force as John or anybody else may have said it, but I think that applying those things with the care and the staff that the prosecution team now has on it, who are in fact the ones who are going to be deciding prosecutorial matters going forward, which is, to be fair, somewhat potentially different than the staff who were doing this from the Division of Water Rights 10 years ago, that they may have a different perspective in applying Tanaka to the facts, and could make your work tremendously easier with a little bit of time up front that, again, we haven't had. So I'll just make that plug. I don't think it should be unlimited, but I do think that all of the facts and law, other than the possibility that Tanaka will be taken up by the Supreme Court and changed, are now in place. And we haven't put those things together since then. So everybody has been proceeding, I think, with a large healthy dose or unhealthy dose of the past and the initial initiation of these proceedings that may not carry as much weight.
Okay, so Mr. Rose, obviously that's good. I will, if these cases settle and we don't have to have a hearing, we'll go on to something else. We've got other things to do, and that's fine. And of course, if the parties can reach agreement, that's often better than the uncertainties of a hearing and potentially follow-up litigation. And if you can't reach a settlement of all issues, reaching agreement on stipulated exhibits, I raised that issue before, and certainly if you can, that's good too. That makes the hearing go more efficiently. It allows all of you to focus on the remaining issues where you have disagreements. And, you're all good and you've done this for many years. And if you have a foundation of stipulated exhibits and then can focus on your areas of disagreement, frankly, I think you can put on stronger cases to advocate for your clients. So that's all good. So here's my question for you, Mr. Rose. What I'm proposing with a September 11th filing deadline for the prosecution team's exhibits, you have over 2 months, about almost 2.5 months, to do all of these things. And I'll just say, why can't you do these, what I'll call settlement stipulation discussions in parallel with preparing your exhibits, parallel tracks over that 2.5 month period?
I can't speak for any of the other parties. I think that if the prosecution team is going to provide all documents that we have, accepting the documents that have just been provided to us, which of course the respondents themselves already have, in the next 2-ish weeks, and then answering any other questions shortly thereafter, we will have some time for that. My concern is that the respondents may be in a go, go, go mode or crunch to do their work because they've asked for more time. And I'm not going to put this forward solely for them or solely for one party. I was thinking it would be beneficial to the hearing proceeding. I think there is some time, but I just wanted to put out there that we have seemingly been in a process-oriented, possibly more adversarial approach deadlines that were not exactly what we expected for some amount of preceding years would be the case when the Tanaka decision came out. So I don't disagree with you that we can multitask to a degree. I don't want to speak for the respondents who may be feeling this crunch differently than the prosecution team. We knew what our case was 10 years ago, and we know our own view as to how the Tanaka decision will have changed it, but just making that plug.
Okay. Well, and I don't want to make your lives miserable, but on the other hand, I think it's pretty clear, at least I think we've got to have some structure and some schedule to get this to move forward, because I mean, I know human nature. I know how it is being an attorney. The proverbial squeaky wheel gets the grease. And I know you all have other matters, and you're going to go with whatever matter has the most imminent deadline. And that's the way it is when you're an attorney with a busy practice. So I'll go next to Mr. Ruiz and Mr. Herrick. Does either of you have any comments in response to Mr. Rose or anything else you want to add before we wrap up today?
This is John Herrick.
Yeah.
We will make our best efforts as soon as possible to sit down or sit conference with Mr. Rose and lay out what we think is dispositive. We'll do that. My question for you, Mr. Lilly, is I'm a little unclear on how this works. So when we bring a motion, some sort of summary judgment or some sort of motion like that, you then write a report as to what you think, and then that report goes to the state board to decide? And would there be discussions between you and the state board outside of the parties before they decided that? How would that work?
Okay, well, it's not a report. It's a proposed order, and it's Water Code Section 1114, and it sets out exactly what we're supposed to do. It basically says that the hearing officer is supposed to prepare a proposed order in a form that could be adopted by the board. Of course, then the board decides, and they have about, I think, A through F for their options on how to proceed. A meaning is they just adopt the order without any changes, and then it goes on from there. So I guess my only point in all of this is I think I can't just sort of be sending proposed orders to the board every month in this matter, one on a summary judgment and then the next on a hearing and so forth, because the board has a lot going on, a lot even besides water right matters. Sometimes we who do water rights have to remind ourselves of that, but they have a lot of things going on. Their calendars are almost always fairly full. So I my charge under the Water Code, particularly Section 1114, is to prepare a proposed order and a related package, obviously with our administrative record, for each matter, and submit that to the board for the board's consideration. Normally, that will be a proposed order after a full hearing. That's why I say that under extraordinary circumstances, it could be a proposed order after some kind of a dispositive motion, either before hearing or after part of the hearing has occurred. I'm very hesitant to do that, I will just say, because I think it's easier for the board to have a complete record. It's easier for me to prepare a proposed order based on a complete record. And then the board has everything to decide how to go forward. The risk is some people might think, well, if you have a dispositive motion, that gets rid of things quickly. But obviously the risk is the board says, well, we don't think we really have had the full story here, and we're going to send that back to the hearings office for further proceedings because we want to have a complete record before we decide it. So I hope that answers your question, Mr. Herrick, but that's my view of what the hearings office process is for this. Does that answer your question, or do you have any follow-up on that?
It kind of answers it. I understand you telling me you don't want me to make such a motion, but we don't have any other questions.
No, and I did not say that. I just said that, you can certainly make the motion, but I'm just saying I will be hesitant to dispose of a matter before there's a complete hearing unless there's a compelling reason for doing so. I think that's different than saying I don't want a motion. I hope you appreciate the distinction.
Well, I wasn't being cynical. I was just being, practically speaking, you talked about how long it would take and how it might interfere. So I understand your preference.
I'm trying to, just want you to understand the practicalities of what I have to work under as well. And frankly, the board as well. So Mr. Ruiz, anything else? Any other comments or questions today?
No further. Thank you.
All right, thank you. And then Ms. Spalletta, we'll circle back to you. Anything else before we wrap up today?
I'll be brief. I just wanted to introduce my summer intern, Noema Oligary, who's been watching the hearing this morning. She's a student in environmental studies at UC Santa Barbara and will be working on these matters this summer. So hopefully we'll see her face, maybe participating as an attorney in one of these in a few years.
If she still wants to be an attorney after watching this hearing, she'll know what she's getting into. We'll say that. And could you just spell her name since we will have it on the record?
Her first name is Noema, Noemma, and her last name is Oligary, Olagaray.
Okay, great. Well, Miss Oligary, I hope I pronounced your name right. Welcome to the process. Seriously, I do hope you find this, I hope you go to law school and find this to be interesting. I've done this for a long time, and I cannot think of an area of the law I'd rather be in. I mean, there are huge challenges, but it's very interesting. And obviously, as all the parties today have pointed out, very, very important for California. So, Ms. Aykroyd, you get the last word here before we wrap up. Is there anything else you'd like to add?
I do not. Thank you.
Okay. All right. Just one last call. I just want to make sure we've covered everything. Does anybody else have anything else? But just so you know, our process, as I said, I will work with my colleagues in the hearings office to get out an order as soon as we can. Certainly we're going to specify schedules, and I think we're going to specify hearing dates, but I understand the tensions that the parties have raised and considerations, and we will consider those. I hope I've explained adequately my concerns about moving things forward. So with that, we will go forward with an order. So one last call. Anybody, anything else for this morning? All right. Well, thank you all very much. And I'm sure we'll be in touch if necessary, anywhere along the way. If any of you think that we need to have a further status conference or pre-hearing conference, please send me an email, obviously with copies to all the other parties. Or if there are any other questions that you think we need to clarify, email is the best way. And as you know from the hearing notice, all I ask is to make sure to copy all the other parties so we don't have any ex parte issues. So with that, I hope you all have a good day, and I'm sure we'll be in touch. Thank you all very much.
Thank you.
Goodbye.